I'm delighted to welcome you all here today for a very special event, one that is truly only possible here at Albany Law School. Today is an important day for two reasons. First, we have not one, but two distinguished jurists who have been the superintendents of one of the most influential court systems in the nation. Second, today, Albany Law Review resurrects its noteworthy Chief Judge Lawrence H. Cooke State Constitutional Commentary Symposium. Say that one 10 times fast, which has been in a state of dormancy since 2019. We are thrilled that you are all here to partake in this momentous occasion, so thank you for being here. A huge thank you is owed to the Government Law Center, which is co-sponsoring this event. Under the leadership of Judge Leslie Stein and Professor Patrick Woods, the Government Law Center has been a great supporter of the Albany Law Review. We also owe a great amount of gratitude to Chell Miller, the one who's doing all the mics, the event coordinator for the Government Law Center, who has greatly assisted us in putting together tonight's event. Tonight's event is just one event that makes up Chief Week. Over the past few months, we have worked with a variety of student organizations to welcome the chief judges to Albany Law School. Moot Court, which invited Chief Judge Wilson to preside over its Gabrielli final competition, has been a fantastic partner in putting forth Chief Week. I would also like to highlight the Historical Society Club, who organized a trip to the Court of Appeals, and BALSA, who displayed informational posters around campus about alumni judges of color for their involvement in Chief Week. To get the afternoon started, I'm going to ask our Dean and President, Cinnamon Carlarn, to say a few words. Her remarks will be followed by Judge Leslie Stein, former Associate Judge on the New York Court of Appeals, fellow Albany Law School alum, and current Director of the Government Law Center, co-sponsor of our event. After Judge Stein, Kyle Durkee, the Executive Editor for the State Constitutional Commentary issue for Albany Law Review, will introduce the speakers of today's main event. While completing his JD here at Albany Law School, Kyle has also been working on a master's in history from the University at Albany. After graduation, Kyle will be joining the third department as an appellate court attorney. Kyle has put in endless hours, mental energy, and consideration into this symposium. He has worked closely with Professor Bonventre, administration, the GLC, the caterer, and me, and what a saint to have done so gracefully. Working with him on this project and many others this year has been a pleasure and full of laughs. And Kyle, I am looking forward to that long-awaited glass of wine later at the reception. With that, I hand it over to Dean Carlarn.
Thank you, Marie-Therese. I'll try not to fight with the mic too much. I think you fixed it just right for me. Good afternoon, everyone. It's my honor and real pleasure to welcome you all to the Chief Judge Lawrence H. Cooke Symposium. And I'm not going to say Chief Week again. We like saying it around here a lot. This symposium, which was inaugurated, as you heard a little bit about, in 2007 as part of Albany Law Review's annual examination of the nation's state courts and developments in state constitutional law, was named in honor of Lawrence Cooke, a 1938 graduate of this school. While Lawrence Cooke served on the Court of Appeals, and especially during his tenure as Chief Judge from 1979 through 1984, New York's High Court was recognized as if not the, to borrow a term from the Empire State for a moment, national leader in protecting civil rights and liberties, despite the Supreme Court's retrenchment in doing so at the time. Given this history and our contemporary moment in time, it's particularly appropriate and meaningful that we're gathered here this afternoon with two of Lawrence Cooke's successors. Like Cooke before them, our two guests tonight are rightly recognized for moving the Court of Appeals forward in the protection of our most fundamental rights and freedoms, once again at a moment where we see seeming entrenchment at the court. Chief Judge Wilson and former Chief Judge Lippman, we really are very honored to welcome you back to our law school. I want to thank you both for being so generous with your time, not only today, but for the many events you participate in our school. As I mentioned last week when the Chief Judge was here to judge the finals of the Gabrielli Moot Court competition, as someone still new to the New York legal community, I'm very deeply impressed and appreciative of the Chief Judge and all the Court of Appeals judges, both current and emeriti. for their very deep and intentional commitment, not only to the rule of law as it's understood and of course evolves through the court, but also to interacting with and helping shape our future lawyers and leaders. One of the great benefits of Albany Law School that I've already come to appreciate, and I know that many of you do deeply as well, is how being in the capital of New York really allows us to have deep and strong relationship, the deep and strong relationship that we have with the Court of Appeals. Our students and faculty here benefit tremendously from the generosity of the many judges who understand the value of sharing their time to help educate the next generation of lawyers and are very generous in doing so. So in closing, I really want to just take a moment also to thank the members of the Albany Law Review and their advisor, Professor Bonventre, who you'll hear from, for organizing this wonderful event. And I know firsthand how hard the Law Review students work. I've seen it, how thoughtful you are, and how well you represent our school. The law school is very proud and grateful for all of the work that you do. And I'm now going to invite, as you heard, another giant of our legal and law school community, former Court of Appeals Judge Leslie Stein, also director of our fantastic Government Law Center. I'm going to invite Judge Stein up here to speak to you now. And so thanks again for being here. And thank you.
Thank you, Dean Carlarn and Marie Therese. I don't know where you went, but somewhere. It is truly a great honor and my delight to have been asked to say a few words at this exciting symposium featuring and celebrating two leaders of our renowned state Court of Appeals and of the New York State Unified Court System. As many of you know and you've heard, I had the privilege of serving as an associate judge of that court for over 6 years before retiring, or so I thought, in June of 2021. But I barely had a taste of retirement before learning of the opportunity to apply for the position of director of the Government Law Center. After being selected for that position, I officially returned to Albany Law School almost exactly 40 years after receiving my JD from this wonderful institution. Kyle asked me to just speak briefly about the Government Law Center, and I do whatever Kyle asks. So I will do that. The Government Law Center was founded in 1978 and has since that time provided nonpartisan legal research and analysis to federal, state, and local governments to facilitate and improve their service to their communities. As part of that endeavor, we bring together a diverse and inclusive group of lawyers, students, scholars, and community partners while informing nationwide conversations on government and preparing students for career as skilled and leading attorneys in public service. And I'm so thrilled to see so many students here today. As director, I have had the good fortune to work with a brilliant, dedicated, and hardworking staff, in addition to the opportunity to collaborate with other Albany Law School staff, faculty, alumni, bar association members, and government leaders, as well as student groups and law reviews. The Government Law Center is proud to collaborate with the Albany Law Review on programs such as this. As a consequence of the work done by the GLC, Albany Law School was recently recognized as the #1 law school in the country for government law. One of the initiatives undertaken by the Government Law Center since I arrived in 2021 was, to no surprise, to strengthen its ties with the judicial branch of the state government, as well as among all 3 branches of our government. Now, turning back to my time on the Court of Appeals, it's difficult to appreciate the requirements of being a chief judge unless you get at least a close-up view. I always worked hard as an attorney and as a judge before joining the Court of Appeals, but none of my former positions demanded nearly as great a commitment to the task as what I faced upon becoming an associate judge of that court. What many people do not realize is that the work of the Court of Appeals includes not only reviewing records and briefs on the cases argued before the court, researching the legal issues to be decided, writing opinions and reviewing the draft opinions of the other judges, but also reviewing and deciding thousands of motions for leave to appeal each year, as well as performing myriad ancillary duties such as serving as liaison to various commissions, the Law Reporting Bureau, the Board of Law Examiners, the library, and the central staff, among many others. For me, the work of Associate Judge of the Court of Appeals was all-consuming. However, I also learned by observation that the work of the Chief Judge involves so much more. And you'll hear about that directly from the Chief Judges, but based on my experience, the Chief Judge does everything that the Associate Judges do. They have no fewer cases or motions to review and prepare, to discuss and decide, or decisions to write and or negotiate with the other judges. What sets the Chief Judge apart from the Associate Judges is not a huge salary increase. It is that on top of everything else, the Chief Judge is responsible not only for the administration and operation of the court, but also of the entire unified court system, consisting of approximately 3,300 state and local judges, in addition to 15,000 non-judicial employees in over 300 locations around the state, with a budget of over $3 billion. The Chief Judge also sets the policies of the court system, together with the administrative board consisting of the Chief Administrative Judge and the presiding justices of the four appellate division departments. As if that isn't enough, the Chief Judge is also the public face of the New York State court system, appearing at countless events day in and day out. In fact, our current Chief Judge says he has 21 public appearances in May. So you can imagine. I was lucky to serve under two Chief Judges, Judge Lippman and Judge DeFiore. Both of them always seemed to be on top of everything and executed their duties and responsibilities with aplomb. To this day, I'm still not really sure how they did. Having served on the court with now Chief Judge Wilson before he became Chief Judge, I have no doubt that he is equally adept at performing his new role with grace under pressure. It is truly a feather in Albany Law School's cap and a tremendous honor to have Chief Judge Wilson and former Chief Judge Lippman here this evening. I thank them for giving so generously of their precious time to the students of our law school. I think you're in for a treat. Thank you.
Hello, everyone. Thank you for joining us as we resurrect the annual Chief Judge Lawrence H. Cooke State Constitutional Commentary Symposium. Yes, I practiced that on my way over here. It is truly a profound pleasure I have in introducing our brilliant set of moderators and panelists as they partake in a program that truly represents the special privilege of being a law student at Albany Law School. Since its founding, Albany Law School has had a deep and intimate relationship with the New York Court of Appeals, and our speakers today illustrate that. Our first moderator is Professor Kanika Johar, class of 2013. After graduating from Albany Law School, Professor Johar clerked on the central staff of the New York Court of Appeals. She demonstrated her brilliance and hard work as she then clerked for Judge Eugene Piggott on the New York Court of Appeals. After Professor Johar's clerkship, she had the prestigious position of being a senior counsel to New York Law Board of Examiners. Thankfully, Professor Johar returned to Albany Law School in 2020, where she serves as an associate professor of law. Thank you for being here. Our second moderator is Professor Vincent Bonventre. Professor Bonventre is the Justice Robert H. Jackson Distinguished Professor of Law and also the faculty advisor to Albany Law Review. Prior to arriving at Albany Law School, Professor Bonventre clerked for Judge Matthew J. Jason and Judge Stuart F. Hancock on the New York Court of Appeals. In between these clerkships, Professor Bonventre was also selected by Chief Justice Warren Burger to serve as a Supreme Court Judicial Fellow. However, in 1990, Professor Bonventre returned to Albany Law School, where he has made a career out of teaching, writing, and critiquing the New York Court of Appeals. In addition to his roles here at Albany Law School, he is also the director of the Center for Judicial Process, the author of New York Court Watcher blog, and he is also the editor of State Constitutional Commentary. It is because of Professor Bonventre that we have the Cooke Symposium and all that it represents. Professor Bonventre is truly a living testament of what makes Albany Law School special. Thank you. Yet, it is our panelists who take center stage tonight, as they're here to tell us what it means to be Chief Judge of New York State. We're fortunate to be joined by two heads of the judiciary branch who have embodied the essence of the Cooke Symposium. Chief Judge Lawrence Cooke, during his tenure as head of the judiciary branch here in New York State, championed fairness and equality under the law as he advocated for the greater protection of rights and liberties for New Yorkers. And today, both our speakers have undertaken that mission in their tenure as Chief Judge of New York State. First, we have the Honorable Jonathan Lippman, who served as Chief Judge for the New York Court of Appeals from 2009 to 2015. During his tenure, Judge Lippman increased the caseload at the New York Court of Appeals. He created a task force to expand access to civil legal services, and he established a mandate for law students to complete 50 hours of pro bono work prior to graduation. Before serving as Chief Judge, Judge Lippman served as the presiding justice of the First Appellate Division, and he also served as the Chief Administrative Judge of New York State Court System. Judge Lippman is currently of counsel at Latham & Watkins in New York City. We also have the Honorable Chief Judge Rowan Wilson, who is the current Chief Judge of the New York Court of Appeals. Upon his appointment last year, Judge Wilson became the first Black Chief Judge of the New York Court of Appeals. Upon his appointment, he also proclaimed that protecting the rights of New Yorkers is his top priority. In his first State of the Judiciary address, he declared that we should consider courts to be institutions that attempt to make decisions that will improve the lives of those that we serve. Prior to his appointment as Chief Judge, Judge Wilson served as an Associate Judge of the New York Court of Appeals. Before his tenure on the bench, he worked at Cravath, Swain, and Moore, where he became the first Black partner after only 5 years at that firm. Thank you, Chief Judge Lippman and Chief Judge Wilson, for being here today. Your dedication and commitment to public service is truly an inspiration for us all, and we thank you for that. It's truly an honor to have you here. I will now give the floor to Professor Bonventre to begin the discussion on the eminence, experience, and exhaustion of being New York's Chief Judge. Thank you.
I need my tech assistance. Before we get going, I want to point out the presence of my two favorite judges, not these two. But the presiding Justice Elizabeth Gary of the Third Department. Go ahead.
All right, so Judge Stein shared a pretty decent job description, right, for the chief judge. You have a lot on your plate. What we'd like to hear is, in your personal experience, or how do you personally view the chief judge role? What do you think is really the true job description?
I defer to the real chief judge.
To the youngster.
So I was always told that the job was actually two jobs in the Constitution. If you look at the Constitution, there are two titles, right? Chief Judge of the Court of Appeals, Chief Judge of the State of New York. It's actually three jobs, and Judge Stein alluded to that. There is the job of being Chief Judge of the Court of Appeals and all that comes with that. That's actually in some ways the easiest part of the job, especially if you've been an associate judge before. Most of that job really is just the judging job. There's other administrative pieces for the court, but not that much. The next job, which I anticipated, maybe not fully, was essentially the Chief Judge of the State of New York, which has an administrative component, working with the PJs, working with the Chief Administrative Judge and the Deputy Chief Administrative Judges, and really all the court administration through the system, the Office of Court Administration, which is, being an administrator, and that job can be as big or small as you want it to be, depending on how loose the reins you like and how expansive you imagine court administration reaches. And we can get into that in a bit if you want. But the third job that I really did not anticipate is the public face of the court's job, which I'm learning can be all-consuming unless we learn how to say no. And a couple of my friends asked me, how is your time splitting up among those three things? And it really kind of is a third now. And I think that public facing part really has to shrink somewhat. But I've got to figure out how to do that.
I'd say from my perspective, it's sort of the flip. of Chief Judge Wilson's experience, where I came in having a load of experience on the administrative side and the public face side, having been the chief administrative judge for longer than anyone could believe. I was the chief administrative judge, and then being the presiding justice of the appellate division of the First Department. So that was, those two parts of the job, it was second nature to me. The sitting on the bench as the chief judge of the Court of Appeals was to me not a learning experience, because I had been the presiding justice of the First Department, but to me it was a brave new world. And I always say that it had a lot to do, being able to do it was having presence that I felt from day one. I had to earn the respect of my colleagues. On the adjudicative side, everyone knew I knew how to run a court system, but did I know how to be the chief judge of the court? And of course, those 2 years as PJD appellate division were invaluable. But just to have a little take on what the chief says about a third. What we used to say, there were two parts to it. It was really administrative and the public face, so closely linked. And I learned to answer the question of how do you do these two roles? What's the apportionment of your time? And her answer always was, and that's what I adopted over the years, was that I spend 100% of my time on each of the jobs. And it's the truth to a significant degree.
Okay, now, that was an easy one. All right. Now I think we want to know some of the secrets, what happens inside,
I thought we did that program already. But
Leon told you, but you didn't tell us the secret handshake.
No. Well, the chief is going to do that tonight.
But we'd like to know, how is it, and I get asked this all the time, what is it about the Court of Appeals gets a chief judge, and sometimes the court's decisions kind of change, and it's hard really to figure what's going on. For example, Chief Judge Lippman was presiding over the court. Somehow you were able to get a fourth vote on some of these cases. The GPS surveillance case, you got Piggott's vote. I don't know if it was her fault. But,
yes.
The Herring case, who'd you give? Vicky Graffio's vote. It was like that. You were able to get a vote. Now, with Wilson, I have noticed, before it used to be in dissent an awful lot. Now I'm noticing the ones that used to be in the majority, they're in the dissent a lot. What magic do you guys perform inside the court? Really, like, what do you do to get these votes, to get a majority when you're the chief? Lippman, you got to go now.
Okay. Well, my belief was always, and I know we'll border into a lot of areas which are overlap. I was always of the belief that it was very important to get 4 votes, that was the game, so to speak. And, I've been quoted as saying that I'm a results-oriented person, and unanimity is not the result that I'm looking for. What I mean by that is that I believe in strong majorities and strong dissents, and that's the way the law evolves. That's what makes a great court in my mind. And to me, part of the chief's role, and certainly other judges do too, we're not the only ones who look to get majorities to get a 4-vote majority, but part of the role is to try to move the court in a direction that you think is where New York jurisprudence should go, where you think the court should go. So what happened in terms of the particular couple of cases that the professor was referring to, I came in, and in the first year, I had a court that was sharply divided. We had 4 judges who were appointed by Governor Pataki, and 3 judges who would have been appointed by Democratic governors. So on any given case, there was often a natural majority in a direction that I didn't necessarily approve of. Not that you know on any particular case. So what happened is, as the professor indicates, during the first year particularly, there were a number of very high-profile cases, including the appointment of Dick Ravitch as the lieutenant governor of the state, whether Patterson could do it by appointment. And on a number of these votes, we happened to get a 4th vote. Or they were all cases that I wrote, and I got a 4th vote. And very proud of myself. And again, unanimity is not my thing. You know, strong majorities or whatever. So great, doing great, a year in or whatever it is. And a number of these decisions. And then lo and behold, there's an article on the front page of the New York Times. On the right-hand column, remember it used to be when you used to have a print newspaper, the right-hand column was the New York Times. And it says something like, new liberal chief judge manages to get majorities from Republican opponents. Didn't say exactly that, but something like that. And they went through all these cases. And how did you do it? I don't remember. I think I did interview it to some degree. And you talked about trying to persuade your colleagues that this is the right course or whatever. But suffice it to say, the punchline, however it's done, and the chief will opine how he tries to get a 4-vote majority. I couldn't get a court for years after that, because once my colleagues read that article and figured I had lured them into going in the other, becoming a liberal court, I could not get a court ever, at least for a while. Anyway. Chief, how do you get the 4th vote?
So this is maybe going to sound a little odd, but I actually don't try to do that in the way that anybody is thinking about it. I don't discuss the cases with my colleagues before they're argued. You know, one thing that's important to me is that we have 4 votes, right? But which way that happens, I don't really, I mean, of course I care because I think it should happen one way, but I'm not actively trying to go and get a 4th vote in any sense like that. If I'm dissenting, I may write something. Maybe that'll persuade somebody else in conference when we discuss the cases. Maybe I'll say something that will persuade somebody who's on the fence, but I'm not targeting a particular judge or counting votes or trying to get to that point. The one thing that is different that I have done, but this really just goes more to making sure that there's there's 2 things I guess I should say. Goes to a majority is that if somebody is recused, instead of waiting to see if that ties, I've proactively been vouching in an appellate division justice so that we don't waste the party's resources, we don't waste time. But you know, we have a randomized system. It's a little complex, but it's a randomized system so that there's nobody trying to pick a particular appellate division justice to get a particular result. I don't want that sort of thing to happen or to be accused of that at all. The one place where I would say that I have sometimes worked extra hard to get a vote is a situation where we've already sort of tentatively voted, gone through conference, and there's a majority, and then the majority starts to fracture, and the judges who are fractured don't seem to be able to work together to get to a place where we could have a writing. And what you might have then is like 2 judges and 2 judges and 3 judges with 3 dissenting, 2 in the majority, 2 in a different sort of majority, and then no rule coming out of it. If I can avoid that by trying to help bridge that gap, then I've done that. I can think of 2 cases, both before I was chief, where I did that, helped do that.
But to expand on what the chief is saying, there are lots of different ways to answer your question, how you get a 4th vote. Sometimes you're actually seeking it, that at some point during the writings, whatever. Sometimes it's the writing itself that gets you a different vote. And sometimes during conference, you actually go around and you say something and the light goes on somebody, one of your other colleagues, and they say, gee, he's not as dumb as he looks, and And,
Yeah.
you know, so there are lots of ways, or sometimes, and this happens more often than you think, you have a fractured court, you can't figure out what to do, and there's a lot of kind of wandering around, and the chief in that particular case would play a particularly critical role, I think, in trying to not have the court look ridiculous. And some courts do this where the decisions are so fractured that you can't figure out who's saying what. They sort of get together a majority, but they're so all over the place. You can't figure out what it means.
You know, there are also times we go around in conference and one judge, or sometimes more than one judge, is in abeyance. So they're thinking about it. They can see things both ways. They're not sure which they're going to vote. And, you know, then when you circulate the draft, whether it's a majority or a concurrence or a dissent, you know that there's a judge that is convincible and is not sure. That's another way that you can get a vote.
So the answer to your question is all different ways. You get a majority. And remember, the 4-3s are what you hear a lot. There are a lot of 5-2s, and there are a lot of cases where it was 4-3 or 5-2 that becomes unanimous in the end because people move over and change sides, or there becomes a consensus in the court for a particular approach.
Okay, I got them going now, you.
Yeah, so I'd like to hear about the role of the court, right? We explored the role of the chief judge. So let's talk a little bit about the role of the Court of Appeals. A couple of years ago, when was this? The Cooke Symposium on
2019.
2019, Chief Judge Lippman, you moderated a panel. I think it was called The Role of State Courts in the Trump Era.
Right.
Okay, so what I'd like to know, or we'd like to know, is how do you view the role of the New York Court of Appeals, both at a state level and nationally, in the era of a more conservative Supreme Court, right? A 6-3 Supreme Court.
Well, I'll start because I've done it before. It's the same Trump era, I think, in terms of the Supreme Court. You know, in my view, the Supreme Court doesn't always represent the values or history of New York State. And we take great pride in New York in protecting the individual liberties of our citizens. We take great pride in the New York State Constitution, as witnessed the name of this symposium. And I still believe that that role is critically important, and that we don't, and I don't mean that we don't follow the law that the High Court of the nation sets out, but we don't have to follow the case law verbatim of what the federal courts of the Supreme Court does. And in my view, and the professor knows because I talked to him about a symposium I did in Manhattan on this issue. I don't believe, and the chief may have a different view because there's been disagreement within the court on this issue, particularly back in the Judith K. and Bellicosa era, where the questions come up in a back and forth on majority and dissent is, do you have to have a particular criteria to disagree with the US Supreme Court or federal courts on a fact pattern that's not so dissimilar? And my own view is that there is no one answer to that. There is no magic formula as to when you could disagree. I think if New York State's law, history, constitution puts us in a different path than the US Supreme Court, you could just go there, just disagree. I don't think you have to go through some, and we discussed this at length when I had that issue, go through some kind of ritual of how you get there. We protect individual liberties in the state. We uphold the New York State Constitution. We look at our own history, culture, case law, and we come to the conclusion that we do. So I think that role from that symposium, the Cooke Symposium a few years ago, is still the same, especially in a court that, in my view, is not necessarily on all fours with New York's jurisprudence or New York's high court, for that matter.
New York existed as a political entity before the United States did. It had a constitution before the United States did, and it has a constitution in many ways that's different from the United States Constitution. There's no forever wild clause in the US Constitution. The voters recently put in a right to clean air and clean water in the New York Constitution. That's not been adjudicated, as far as I know, by anybody, but it's there in the Constitution. It's not in the federal Constitution. There's a thornier question I have for anybody who'd like a research project, which is the following. What happens in this situation? You have a precedent of the New York State Court of Appeals from, 30, 40, 50 years ago, something like that, that says, as we interpret Clause X of the New York Constitution, it's the same as the federal Constitution. And at the time that was done, the federal Constitution read in the way that maybe many people here would think that it should read. And then, 40 years goes by and the Supreme Court decision wipes that out and says, no, actually, the federal Constitution for this clause means something 180 degrees the opposite of what they said 40 years ago. What's the precedential value of our decision that says we're in lockstep with the federal Constitution? I don't know the answer to that. Good research project. Anybody wants to do a paper on it or something? But to go back to the way the question was framed, I don't actually think that my responsibilities are any different, whether this is the Trump era or the Kennedy era or anything in between. My job is the people of New York, the New York Constitution, the New York legislature as it passes statutes, is to do my best job to interpret those things. I really, if other laws constrain me on a federal constitutional issue, there's nothing I can do about that. But if they don't, then they don't.
I have to say, when I think about the great chief judges in the history of New York, that's exactly what they thought. This is New York. We're going to do what's right for New York. And plenty of them, whether it was Irving Lippman or Stanley Fold or Chief Judge Cooke, they said it's basically irrelevant what the Supreme Court does as long as we're not violating federal constitutional rights. We do what's right for New York.
But you remember when Judas Kay first started the state constitutionalism theme, Brennan had raised it. But Judas Kay sort of latched onto that, and in some of the decisions raised New York state constitutionalism. At the time, it created quite a stir as to what do you mean? You don't follow the U.S. Supreme Court tells you what the law is. But today, I would say that, and you would know better, Professor, that New York is not the furthest, extreme of that.
Not at all.
That there are lots of state courts, the high courts that, go the wrong way.
No, there was something very peculiar that happened in the mid to late 80s. All of a sudden, the Court of Appeals started questioning whether it could be independent, which in my view was kind of ridiculous. But there were a lot of fights at the court.
Internally, right?
Yeah.
Yeah.
But another thing about where chief judges have disagreed is caseload. Can we talk about caseload? Because you both confronted that. Especially the criminal caseload when Chief Judge Lippman took over, and the caseload generally, right, when you've taken over. So what should you do about the case? Should it be as low as it's been? Should it have been more than it's been? God forbid, it shouldn't be 700 cases a year, like when when Cooke took over. It shouldn't be that. But how do you go about increasing the caseload, and what would be a good caseload for the Court of Appeals? Chief Judge Wilson?
I'll give some history after the chief gives what he's dealing with today. Go ahead.
Sure. So we hit an all-time low. I've forgotten which year it was. It might have been 2020 when we had 81 decided cases, of which I think 31 were without argument. And that was not really pandemic driven. There may have been a little bit of a pandemic effect to that, but it really wasn't. I think it was a deliberate effort to shrink the docket. And I look back at the numbers in Chief Judge Lippman's tenure, and there were several years where the total number of cases decided was like 250 or so. And I have a hard time imagining my court deciding 250 cases a year. I think that's the quality of what the work we could put out, I think, would suffer. That doesn't mean that Judge Lippman's court wasn't able to do that. I think they were able to do it, but I would have trouble myself doing all the other things that I want to do and trying to meaningfully consider 250 cases. On the other hand, 50 argued cases and 30 on the non-argument track is too low. And I've said many times publicly, if the job of the New York State Court of Appeals is to sort of set the law for the state, you can't really do that with, 80 cases. You need a bigger number than that. And I think that we could very easily, well, we could reasonably handle double that number, I think. 150, 160, 170 cases a year. I think we can manage and still produce what I would consider good writings, thoughtful decisions. How do you go about doing that? Well, cases come to us in a number of different ways. The appellate division justices can send us cases, and I have said to them quite directly, not just the PJs, but many others, that if they have a good case, just send it to us. And don't worry, if they send a couple extra cases, we do have the non-argument track if there's something that comes along and we think, this is pretty simple. I will, this is a statistic that I haven't seen your report on, and maybe this, but you're just the guy to do this. My impression, so let me not start with my impression. I did check out the origins of the SSM procedure, and it was back when the court was having 800 or 900 cases a year. And in the first 2 years, and this was a Judge Bellicosa invention, there were 250 approximately each year cases put on the non-argument track. And out of those 500 cases, there was one in which there was a dissent. Because the rule was if any judge on the court said, I don't want this on the non-argument track, it came off. When you go back to, the last several years, and I think you've noted this, there were lots of cases on the non-argument track that had a lot of dissents in. And I think, but I don't know because I haven't tried to count, that in the last year, you would find many fewer cases on the non-argument track, and I think you would find many fewer dissents as a fraction of those cases on the non-argument track. So I think we're going back to the use of the non-argument track for cases where really there's unanimity, or at least very close to unanimity, predictable when the case comes through. The other things that I think, we can do about increasing the number of cases is make a volitional effort to grant leave more on our own. And, it would help. This is something that even when I was a practicing lawyer, I kind of scratched my head about. The second department is overworked. They don't have enough judges. They've sat in panels of 4 as long as I can remember, but the chance of getting a 2-judge dissent, which would entitle you to an automatic appeal to the Court of Appeals, when we have 4 judges, is statistically lower than if you have 5. And although they will vouch in a 5th, they only do that when there's already a 2-2 tie. So we would get more cases out of the second, which is the biggest volume department. I think it's about 40% of the cases in the state are from there. If they could sit in 5, but they feasibly can't do that.
Let me just say, I agree with Chief Judge Wilson that there's no magic number that's right, that the amount of cases you hear or not here. But to fill in a little history to it, when my predecessor, the great Judith Kaye, had a very different view than Judge Wilson does about the appellate divisions and what they should be sending to the high court. And the court had a mindset at that point that don't just send us stuff, don't use your own judgment about that. It's a rare thing indeed. We want something, we'll take it. And so there was a gradual reduction in the caseload in that regard. And then on the criminal leave stuff, there was again a mindset that you shouldn't bring a case to the high court unless it really was an important point of criminal law. Because otherwise, you're going to get some bad law coming out of it, and it should only be the rare case that went up. I came into the high court, the appellate division, which I had already seen that the disrespect that criminal defense attorneys were treated in oral argument shocked me. When I got on the appellate division, what is the presiding justice, and it shocked me, offended me, because it's so important that people feel that there's a level playing field and you can always get your day in court. So when I came to the high court, on the criminal side, we right away, that issue came up because there's a lot of unrest in the criminal bar, defense bar about this. And I did an interview with the law journal. We were talking about that beforehand, where I said that it's important that everyone gets their day in court, and And it's certainly, as I was concerned, you know, I think it's important to grant criminal leave application, not that you always win, but that the perception that the High Court is a place where the people's business is done was important. And also in this article, they started to, I didn't say anything, Chief, you know, we never speak about our colleagues, right? I didn't, but in the article, the law journal started talking, had numbers about how many grants the different judges had done, and started giving the nicknames that different criminal defense attorneys called some of the judges about this. And lo and behold, no time whatsoever, the criminal leave application grants went way up. And I certainly, on the other front, I agree with the chief, with the appellate divisions, and Beth, you know, I'm sure you'd agree. Sometimes the appellate division wants to send its cases, and it makes sense to do so. And I didn't see any reason to turn off that spigot either. So I think there are a couple issues. One, again, there's nothing magic, and I agree with the chief. But the people's business needs to be done, and the public has to understand that the people's business has to be done. And the most downtrodden of our litigants deserve to get to the High Court just as much as the people who can afford very high-priced lawyers who can make all the great legal arguments to get you up there. So I think caseload is important, and I know the chief does. And, you know, I've seen through some of the professors' writings, the increase in the caseload of the court, the increase in criminal leave application. And I'm a firm believer in both, without, again, putting any, there's no formulas that it has to be that people know that the High Court it's not just the lowest court, it's the people's court. The High Court is also the people's court.
I just want to go back to the appellate division for a second. So the Constitution gives the appellate division justices the right to send us cases. It is not my business to tell them, don't exercise your constitutional right. I wouldn't do that. That seems crazy to me. Second is, they are every bit as talented as I am. Many of them have much more experience with the judicial system than I do. And who am I to say this is not a case that's worth coming up? I don't want to second guess that and be in the business of second guessing that. What we can do if it comes and we think that, you know, this shouldn't have been here, it's a really easy case, we can put it on the SSM track. If there's some appellate division justice who seems to be slap happy about doing this with cases that are meaningless, then I can go talk to that judge and explain, as you would to anybody, here's why these cases are really not ones that are worthwhile for us to handle. But, you know, by the time the panel of the appellate division has decided a case, they know it really well. They know it better than we know it when we're trying to assess it in a leave application. You know, if I haven't said that loudly enough, they know what they're doing.
Well,
Well,
I think it's a good idea when my favorite judges grant appeals at the Court of Appeals.
But Ben, you know, that was a very great source of controversy at the time in Judith's day, that, you know, appellate division felt almost dishonored, you know, that, what do you mean we can't send, as the chief says, who better send this cases than those who know the cases the best? Because we're getting it, you know, later, and we'll take a look at, you know it better than we do.
Well, after that article, actually, Chief, you tripled. And, you know, he says he didn't have anything to do with it. Oh, give me a break. So all of a sudden, the criminal caseload tripled. Yeah. Go ahead.
Yeah, so I wanted to touch on criminal leave applications a little bit.
You're
So
doing your former boss's bidding now. Go ahead, let's hear it.
this is the subject of great.
Yes, I know.
Judge Piggott. So
We both know. We've heard him opine on this issue. Go ahead.
opinion a few times. So criminal leave applications receive the review of a single judge, right? And civil motions for leave to appeal go to central staff. Central staff thoroughly reviews it. I was on central staff, right? So I'm giving myself some credit here, right? You thoroughly review the case and then you offer a recommendation, right? A leave grant, deny leave, grant leave for appeal. So What are your thoughts about the criminal leave application process?
Can I ask you a question?
Please do. Go.
Back in the day when you were on central staff, what would you say was the percentage of leave applications where the recommendation was to grant? These are civil cases, not criminal.
What percentage
Yeah.
did we grant leave?
Would you recommend?
Recommend.
Recommend a grant?
Not often,
Yeah, like
Yeah.
2%, 3%, something like that?
right? But we
So-
received, so when I was there, sorry, I didn't mean to interrupt. Go
No,
ahead.
no, my point was going to be that if you were, I mean, I know you didn't directly suggest this, but imagine if instead you either shifted it so that the criminal leave applications went to central staff, or you built a central staff to consider the criminal leave applications, which have a bunch of space-related and cost-related issues, but leave those aside. You might end up with a 2% grant recommendation the way you're getting on the civil side. I don't know that, but it's not as if the grant, that the percentage of grant recommendations coming from central staff is very high.
Right,
There's a lot of those that then get second guessed by the court. Second guessed maybe is not the right word.
right.
The court grants even where
Additional
central
review,
staff
right.
has recommended denial. And then that's what you then see the total number. So I'm not sure that's the.
Yeah,
how
it
to
may
see
not
that.
lead to an increase in the number of leave grants. I just wonder if having an additional set of eyes, right? Would we consider maybe adding 2 judges to the criminal leave application
So that was
process?
something I suggested when I bombed Judge Smith and Judge Piggott's then panel.
Isba panel?
Yeah, the judge. So there was a panel that Justice Denise Hartman ran, and it had Judge Piggott and Judge Smith and a couple of people on it. And I wasn't at it in person, but I was watching the whole thing or listening to the whole thing. And then I sent in a question through the chat, and Justice Hartman said, well, we've got this question, but we're not really sure if it's from Judge Wilson or not. But the idea was to circulate the criminal leave applications to 2 different judges randomly, with either one being able to grant. And it's, something I'm still considering. The clerk's office is looking at the feasibility, and a sticking point may be, what do you do when one judge wants to conference it? Do you then loop the other judge in, or do you not? Because the idea is it's supposed to be 2 independent. So, we have to think about that a little bit. Judge Piggott, I know, wants every leave application to go to every judge. And we don't have the resources to do that unless you want us to go back to deciding 50 cases a year and handling a lot of leave applications, which probably doesn't do anybody any good. And maybe Judge Lippman can or Professor Bonventre can fill me on this. My understanding is way back in the day, you could, if you were it could be the people or the defendant, you lost in the appellate division or a criminal case, you could go to any justice of the appellate division you wanted, or any judge of the Court of Appeals you wanted, and ask for permission to leave. And that, in some ways, is the fairest system, because it's sort of take your best shot. You pick the judge you want, and if you don't get leave, you don't get leave. The problem, of course, is that certain judges would get lots of work, and others would get sort of very little work. But in some ways, that was the fairest system.
Then is that the way it worked when you were in the court in the
It
old
was
days?
before my time.
Yeah, I don't remember that.
No, it was
But let-
before, but I think there was a time when it was like that.
But let me just say my view. Of course, it has to be my view, because Piggott would kill me. Is that something has to be done to take it away from the whim of one judge. That's the term he always used. So the whim of one judge. I think it can be very unfair. And when you get a court, for whatever the reason, we're talking about, it goes up, it goes down, whatever the flavor of the moment is. Some people never grant criminal leave applications. And another pair of eyes in your words, I think is good, whether it's the system of 2 judges, which I like that, by the way. I think that makes a lot of sense, whether it's spending the money to build a system, although if they only recommended 2%, that wouldn't necessarily solve the problem, or they went back to it that really existed in the old days. One way or the other, I do believe that not good to have just one judge looking at criminal leave, dealing with matters of, people's lives and death and liberty, and I think it makes sense. So you told Judge Piggott that I did that. And also Judge Wilson too, we are both, doing his bidding, okay?
So
Tell him.
let me give you the devil's advocate point of view. here.
He's gonna go back and tell Judge.
No, but he's never done it before. And this is just, you know, as a good lawyer would do, to take a side of an argument that you don't necessarily believe in and present it as best as you can. If you think of the role of the Court of Appeals as setting the law for the state, not as an error correction court, then one of the things that affects whether we grant leave in any kind of case is this an issue that is going to recur? If it's a one-off, you know, then it's just error correction. If it's a recurring issue, then it's something we should get. So on the criminal side, if it's a recurring issue, then eventually some judge who has a higher grant rate will get that issue and will grant it. And at that point, then the law of the state will be set properly. So if you have that view of the role of the court, and if you think that view of the role of the court translates equally to criminal cases as it does to civil cases, then you're not so upset about the system.
Yeah, and you know what's funny, Rowan, that when this issue first came up, you know, when I first came in, that was the argument of a number of my colleagues was, look, this is not error correction, you know, that's not the role of the court and all of that. So it's interesting. It does matter how you come at it. And there was a level of great comfort that they, you know, from that perspective, that they weren't granting a hell of a lot of, you know, criminal leave applications. And I felt for other reasons that made that argument not as potent as if you took it strictly by the numbers, you know. I think that there are reasons why you want, again, people to get their day in court. But it's such an interesting issue, and I think it's one that the chief will continually find bubbling up on that question. You know?
Yeah, I mean, this is kind of a particularly good time if it's feasible to try the two judges.
I like
look at
it, Rob.
because for the first several years I was on the court, each judge was every month was getting sort of 32 to 35 criminal leave applications to decide. And for the last couple of years, we've been getting 17 or 18 a month. So right now, if we were to double it, it would really only be the workload that I had when I first started. Now, there are several judges who are on the court who never had that 35 a month workload, but I know it can be done. Judge Stein knows it can be done.
Well, you remember that, you know, when we did have backlog issues in the court, when they come up periodically, they're often because judges are just dragged down by the number of the criminal leave applications. I can't keep up with it, and yet they're trying to do their other work. So they're all kind of interwoven, these issues.
Yeah, but no matter, and you both know this, I mean, no matter what you think about how many criminal leave applications ought to be granted, you do know that, well, Lippman, you had somebody on your court, and Chief Judge Wilson's got somebody on his court. It's a black hole. If you are a litigant trying to get to the Court of
Yes.
Appeals and randomly your application is assigned to a particular judge,
Projects.
you get, now the Court of Appeals doesn't publish these, but I do the tedious work. And you've each had judges, Lippman a particular one, and you've got one that they grant less than one a year. I mean, so they're hearing about 300 criminal leave applications and they're not even granting one each year. I mean, so for the litigants, isn't that a bit unfair?
I think it's unfair, and maybe that they're overwhelmed, which goes to
Yeah.
other solutions that let somebody, another pair of eyes, take a look at it, whatever the system that might work. You know?
Higgett's got that great story, right?
Yeah, I think he received a case from,
Well, you don't have to mention who the
Yeah,
judge
he
was, but
received
the
a case.
CLA had been denied.
right, and he was the second set of eyes on the
On
case,
re-argument.
and he granted leave, and the conviction was overturned. Actually, so that was kind of his.
Well, you know, the argument,
action.
again, there are lots of arguments. One of it is you're going to make bad law. If you have too many cases that you bring up, you're going to make bad law. And sometimes a person's life was saved and it wasn't bad law. And other times if the person lost, so they lost, you know?
Yeah, no, what time is, we open it up?
Yeah, let's open it up for the
We
students.
can ask the law review what they'd like to do.
Yeah.
Open it up. Kyle?
Let's open it up to the audience.
Hi, thank you both for coming and speaking with us. I've really been enjoying this conversation. My question is, how do you communicate with the governor and the legislature on matters that relate to judicial reform and the state budget? And how do you do that in a way that won't lead to you being recused if that matter were to come before the court?
Chief. Who knows, I give you all the hard ones. Go
Oh,
ahead.
no, it's just going to be a long answer. So one of the things that that I've been doing differently, and I've had it having the court system and OCA do differently, is we are much more involved with legislation than previously. So in what this is a little bit of a cartoonish version, but what used to happen was we would sort of wait till bills, well, unless it was a court-sponsored bill or something that really directly impacted the court system would wait until the bills got through both houses, they got to the governor, and the governor had to call for the bill to come up. So before the governor called, people would then sort of scramble to figure out what's our position on this bill, do we want to take one or not, and then maybe write a memo about it, get that memo vetted, and put it in. What I've instructed people and what we're doing now is that the moment legislation is introduced, even if the pushback from this was, well, most stuff doesn't actually even get through committee, they don't care. It's introduced and take a very broad net about what things we might care about, which include public policy sort of things that don't directly impact the courts, but involve the judicial system, whether it's criminal justice or civil. Let's know about those. Let's figure out what our position is. Let's get involved in helping the legislature draft and then footnote or separate paragraph or something here, side note. The legislators generally have ideas. And some of those are really good ideas and they're responsive to problems they see. But because they're not the people actually doing the work, particularly when it comes to courts, they don't really know how to write the words that implement the idea properly. And so left to their own devices, they have a great idea, they implement it in some words, and then there's a mess. And the idea is that if we get involved in that earlier and just tell them, here's a memo, here's a markup of your bill, these are why you should do things differently, and you'll get what you want, and you won't cause the following sets of problems. We've been involved in that right from the beginning, and I've had legislators come in and said thank you, and where's the memo, and so. But your question is, having done that, how do I prevent myself from being recused? And so I have to make, and this is a discussion that I had with our new OCA counsel who raised that exact question. And my answer was, there are going to be times when other people, not me, can do that, right? They sort of, I can talk with them generally maybe about what the court's overall position on the legislation should be, oppose it or not oppose it or try to fix it. But the details of, how they're going to fix it and what comments they're going to send and so on, I don't really have to be involved in. And usually I'm not the right person to be involved in anyway, because these are specialized enough areas that I don't know much about. But there may be certain legislation where I do need to be involved directly, and I'll make that choice kind of a priori. And that means that I'll recuse myself if and when that legislation ever gets challenged. Some of that calculus is the legislation ever going to be challenged? But some of it also is just where is it more important for me to be involved? And it's just a judgment call by me. And, I haven't made a mistake yet, but that's because I haven't been tested yet.
Well, I agree with the chief on that if you're involved and you have to recuse, you're going to recuse. My basic view was that anything that affects the judiciary, directly or indirectly, we know about those things. And we should be telling them, using our expertise and knowledge to tell them things that they should know. And, I was never hesitant about doing that. I think sometimes it's kind of awkward. I used to go over there when I thought it was appropriate, and you're walking through the halls and it's, people looking aside, what's the chief judge doing and why are you there? Or the reporter says, what are you doing there? I think it's important that we be proactive in that regard, but that didn't stop. Aside from the issue that you raise about, it may come up in some way and you have to deal with that. I many times I had the chair of the Judiciary Committee saying publicly, he thinks he's a legislator instead of the chief judge, Well, my view is when it comes to the judiciary, we do know what's important for our branch of government. We do have the ability and the duty to tell them what we think. And I agree totally. The chief had told me that early on he was going to take a more proactive role with legislation. And that makes sense to me. And I don't think we have to be sheepish about it, even though sometimes for a variety of reasons, it can be awkward, you know? And you know, I could tell you so many fun, interesting stories about when I was the chief administrative judge and Judith Kay was the chief. She used, and if we go over to see the majority leader or the speaker, she particularly would go see Joe Bruno. You know, who is this? You know, very much he was a horse trainer or whatever the hell he did. And Judith Kay would come in, and every time we'd go to see him, she'd come and bring him a bouquet of flowers. And the guy didn't know what in the world to do with these flowers, you know? She was obviously, in one way or another, trying to influence him, but all's fair and, you know, love and war with the legislature.
We're working very hard on the love end and rather than the war end. Paying dividends. We got a salary increase for the judges. We
Absolutely.
got the judicial security bill passed, so things are looking pretty good.
Love works, chief.
Yeah, it does.
I love
It does. Love works.
Might I say though, just to add a little political undertone, it helps when the governor is someone who appointed the chief. It helps to give a little love and you feel good about each other and it works. Because I've been in situations, I've been in both, where I was not the judge who the governor appointed. And it was not always the smoothest of sailing. And sometimes it almost felt like war, but that's part of the history of the judiciary. If you go back at all of our predecessors, there were times of, you know, the greatest collaborative relationships. I remember the days when Saul Wackler sued Cuomo, you know, even though he appointed him.
Right.
Oh,
And I don't know that a chief judge has ever asked the governor to come to the state of the judiciary, but I asked Governor Hochul to come and she came and she spoke. And most of it, I don't think she knew this ahead of, I'm sure she didn't ahead of time, but most of that, the state of judiciary was focused on our specialty courts, so mental health courts, drug courts, veterans courts. And yesterday, she held a press conference at the Manhattan Community Justice Center, which is one of our little specialty courts, to announce her mental health initiative that's in the current budget. And the day before, I got a note saying, and could you please come and speak? And so, you know, there's the two of us along with the program director for the courts from the Center for Justice Innovation. The three of us sort of giving a joint press conference. And, you know, I think the fact that she appointed me and she even referenced that fact, I think in the press conference. Yeah, you're absolutely right. It's a good thing.
well, you know, Wackler, not that keeps telling war stories, it was the thorn in Wackler's behind that the legislature really wasn't the governor, although the governor told them what to do to the legislature would never invite him to give the state of judiciary in the legislature, like they did in some states. And it just burned him. I can't tell you. He hated it. He hated it. You know, so, but the different states have the same issue. That's the point of three branches of government and how do they collaboratively deal with each other, and sometimes collaboratively and sometimes not so much.
He, of course, was a great speaker and he would have he would have Wacklerized.
Yeah.
You used to Lippmanize. He would have Wacklerized all the legislators.
Yeah.
I think Isabella's got a question, Kyle.
Thank you both so much for coming and speaking with us. It's been a pleasure to hear this conversation. Something that I noted and I found interesting throughout was how law review articles that maybe Professor Bonventre has authored or other scholars can change the voting or decision of one specific judge. And I'm curious to know, as chief judge, do you find it part of your role to address that situation at all? Or do you believe that you should be actively reacting to the public's perception?
Is the question is, if there's a law journal or a law review article commenting on the work of the court?
Not on the court as a whole, or the direction the court as a whole as it is taking, but rather the situation that was illustrated where one judge may be being criticized for being too liberal or too conservative based on how they vote with the criminal leave applications. And that may change their conduct. So not the court as a whole, but maybe one particular judge.
Well, that's a tough question. We never ignore Professor Bonventre's. But we do try in general to not be overly influenced. Some lawyer does a column in the law journal, saying God knows what about a particular thing that a particular judge did or whatever. I think we're human beings and we read all that stuff, or often do. But it's not particularly the role of the chief unless it's impacting that judge in a way that has some effect on the court, It's an interesting question.
Yeah, let me defend myself.
She doesn't talk
It's not about criticizing the court. You just point out the facts. The judges are voting if they're not granting any criminal leaves, and then they're embarrassed.
Yeah,
Or not.
Or not.
Or they're proud, or, I don't know.
Yeah, but what's interesting about this? Having been in different roles in the courts over the years, we talked about it a little bit before we started. There were times when particular judges are saying that Bonventre or that reporter or this person or whatever, I can't say what. So they're reading it, but let me put a bouquet, give you a bouquet. There are so few places, and Albany Law School is one of those places, that focus on the work of the High Court, that it's such a delight, even when it's critical or it's, laudatory, whatever it is, that some place, some law school, some law review, is concentrating on what comes out of, if we believe what we all spout, that the work of the state courts is so important in today's United States. God knows some of the law schools and the commentators should focus on what we do. And it is, in my view, shameful that there's not enough focus on the work, certainly in New York, where again, Albany Law School is the place that focuses on it. But in all the state courts, there's not enough of an emphasis on our work and the trend setting cases that come out of, the high courts and the other courts, the appellate courts in our state courts. So
Albany Law School, of course, is in an ideal location.
Agreed.
Because we're next to what in most of its history has been the greatest court in the country. And I even
We
said,
agree, right?
and I even said that in front of Justice Sotomayor, if you remember. Yeah.
I do remember when you said it.
Hello, for Chief Judge Wilson, I'd love to ask if there's any case in particular that you thought was the hardest for you to decide.
Hardest to decide? Well, I guess not sure that I think any case has been that hard to decide. Some of them are harder to write. Some of them, when I'm dissent, stick in my craw more than others. Sometimes a dissent doesn't, it's not that I didn't think I was right, but it's the consequences. One, as long as people know what the rule is, that's fine. And it tends to be more in the civil cases than the criminal. But, and there's certainly cases where I went in before argument thinking one thing, and then after the combination of argument and conference, I changed my mind. But I guess I don't view that. I view that as kind of part of the decision-making process. I don't view that as hard to decide. So I'm struggling to answer that one. There definitely cases have been hard to write.
Or hard to get a court. You know, it's not the case, it's so hard to decide, but the court can't agree on which way to go.
Thank you to you both. You both kind of touched on this when you talked about writing your majority decisions in the beginning, but I was wondering to what extent is the audience for your dissent opinions? Is that to try to convince the other justices in the majority? Is it just for the people of the state of New York? Is it for future justices to look back on, or is it mainly just for esteemed court watchers like Dr. Bonventre?
Should I start this one, since I think I was on a pace to set the record number of dissents in the
Here,
court
here.
history? And let me preface that by saying Professor Bonventre noted that I'm not dissenting as much, which is definitely true. But the reason mostly is just that my seat has changed. And it's the way that dissents were signed. I don't really want to go into it unless, I mean, I'm happy to go into it. It's just a long explanation, but, if I had really fully comprehended this, I might not have put my name in the ring to be chief. Because in some ways dissents are more fun. You always like to be on the winning side, but writing a dissent is it's a much more, it's just a better writing, just in terms of pure writing. So, but every time I'm contemplating dissenting, I always ask myself, what purpose would this serve? And it would serve, if it would serve no purpose, then I really won't do it unless, and there's only been maybe one or two cases that fall into this bucket. I just couldn't live with myself unless I wrote the opposite. But the purposes might be, and it varies from case to case, the purpose might be to, and this has happened several times, to circulate a dissent to cause the majority to change something, even if they're not changing, not coming out a different way, to change the writing in a way that then would allow me to join it. Sometimes it's to force the majority writing to improve itself, even if I don't join. Sometimes it's a message to the legislature. You know, this is not right, and you need to do something about this. The best example I can give you that is the Redbridge Bedford case about the injunction that a commercial tenant can get to sort of stay the proceedings while you get a determination about what a lease requires and doesn't require. I think within something like 6 days of the opinion being published, a legislator, an assembly person introduced legislation to reverse it, and within a few months, there was legislation reversing the decision, expressly saying it was reversing the decision. So sometimes you write for the legislature. And I don't think I do this very often, but maybe occasionally writing for some distant future. I sort of think of Happy the Elephant that way.
Well, I agree with everything that the chief said. My own view is I always felt it was important, in addition to the reasons that the chief mentioned, to put a stake in the ground. His last point that the law evolves in New York, more common law courts. I thought it important to say something that New York jurisprudence will be able to latch on to later on. And there's a whole theory about when you dissent and when you don't. Again, my theory, I mentioned before, I think that's how the law progresses: strong majorities, strong dissents. And as Judge Wilson indicated, you're in a little different role when you're the chief. Not that I hesitated to dissent, you know, when I'm the chief too, when I was the chief. But I do think you're in a little different position. But, you know, Hugh Jones wrote a famous article about when you dissent. And he said that you only do it in a matter of the highest moral issue that you must dissent. Sort of when the Chief Judge Wilson said, well, you can't live with yourself if you don't dissent. But I think he viewed it too narrowly. And I think that dissents are good, not bad. And I wore them as a badge of honor. If you dissent too much, it means you're not getting too many courts, you know, if you're always dissenting. But I think putting that stake in the ground is something that matters. And that's how the law moves from, you know, one place to another. And particularly, I think there are times and it varies. And Chief, you've been on two different courts. The makeup of the court sometimes matters and really leads you to dissent more than you might with a different makeup of the court. You know, where there's natural majorities and minorities and how you feel about it. And sometimes you get, and I have to be frank, sometimes you get very frustrated when you're seeing the law go in a direction that you just don't think is right. And for the future of New York, I think it's important to dissent when you see that happening. But I don't agree. And you ought to look it up. Where was it? It was in a State Bar Journal where Jones wrote that piece that
Cogitations on, yeah, he did that at the City Bar Association, the Cardozo
that you
lecture.
only dissent in this, when it's really, really something, and otherwise it's a collegial, yeah, it is collegial. But again, my own view is our only goal is not to find consensus. If you feel strongly about the law, whether it's on moral grounds or just, legally it's wrong, you should state your case, and strong majorities and strong dissents, in my view, make great courts. And that's when you get courts that are recognized nationally.
And what about, do you consider the fact that the Court of Appeals jurisdiction is rather narrow? But the appellate division, of course, could exercise interest of justice. And you know what I'm talking about, People versus Tiger. Your court, you weren't chief yet. I mean, one of the outrageous decisions. The court knows that this woman is innocent. And on a technical legal ground, they affirm her conviction because she had pleaded guilty, right? Goes back to the appellate division. Thank God for the appellate division. They said, well, we're not going to put up with this. And in the interest of justice, they threw out her conviction. Do you sometimes think about, well, maybe the appellate division can cure this because we can't?
Oh, sure. And Tiger's a good example of that because she had not just the actual innocence claim, but she also had an effective assistance claim. And I think if you look back at my dissent and look at it, it's that one is written for the appellate division and for the legislature, but for the appellate division.
But the answer is yes, we think about it.
Yeah.
And that, yes, it's very restrictive to be not very restrictive, but to be a court of law, as opposed to, I've been in both places, that the interest of justice, it really does make a difference. It's interesting, when you talk about the Court of Appeals as a court of law, when we go to these interviews, when you're, want to be the judge of the court or whatever, and they say, well, it's a court of law. And I'm quick to say, yeah, it's a court of law, but it's also a court of policy. And I don't believe it's a straight court of law. So, but it is, then you raise a very good point. It is.
Can I ask one of my favorite judges, do you think that when the case comes back to you from the Court of Appeals, do you think of, well, we do have the power of the interest of justice? Do you often think that?
We often think of the power of the interests of justice. We think about it a lot. We are very cognizant of the difference in the role of the mid-level and the highest court. It's something that we're constantly aware of. We do frankly have a broader power. We have all of that. We have a factual review power. It's a different court that serves different ends and means. And we are, most notably, we are a court of error correction.
Yeah.
That is what we do.
Yeah.
And because you called on me, and I will turn it over to Judge Clark. But because you gave me a microphone, I am going to say, the interesting thing from the appellate court position with dissents in the Court of Appeals, my personal experience has been sometimes that's difficult because the Court of Appeals might enunciate a rule which is unpopular, which perhaps I, in my tremendous wisdom, might find to be not the rule I wish applied. And if there's not a dissent, I could sort of chip away at that unpopular, in my view, rule. I could say, well, but they meant this, but they didn't mean that. They certainly didn't envision this set of peculiar facts and circumstances arising, and I could sort of like work with that. But when there's a strong dissent, that door gets closed because I can no longer in conscience say, well, that they must have overlooked this situation. So there's a constant interplay, and I won't go on too long but that role and the distinction of the role of enunciating law and working with facts is very much in our minds.
I think relative to the interest of justice, one thing that on occasion we've thought about is if we decided on the interest of justice, then the Court of Appeals may not actually be able to take it.
Yeah.
So that has come
Is that a
into.
good thing or a bad thing?
Well, sometimes it's a good thing.
Sometimes it's a good thing.
So we've had those conversations. If we invoke interest of justice and decide it can't go up, can it? And then you're talking to other people on your staff saying, can this go up? Would this not go up? And, Chief Judge Wilson wrote, I remember, I don't think you were Chief Judge yet, but you wrote a case and talked and kind of implored us to use our interest of justice jurisdiction more. So
Yeah, I think of it
appreciated
longingly, that the interest of justice power.
Yeah.
And Presiding Justice Acosta once told me that I would enjoy being on the appellate division more than on the Court of Appeals.
Well, let me just say on that, I've had the privilege of being presiding justice in both courts. And in many ways, you do have to think twice, why am I going there when I have this wide berth, the appellate division to do good things,
And something that Presiding Justice Gary said that dovetails with the question about hard to decide cases. Sometimes in the Court of Appeals, you see these very short memorandum decisions. There are 3 or 4 sentences and that's it. And some of those are really easy cases. Some of those are actually the very hardest cases where we couldn't reach a result in a longer writing, and the only way to dispose of it was in something very short that wasn't really going to have precedential value because, people realized that if we write a long dissent in this, it's going to cause exactly the problem you just heard about. And so we're not going to do that. Instead, if the majority will agree this is just 3 or 4 sentences and dispose of this case, we'll worry about the precedent in some other case where the issues line up better. Sometimes those cases take a huge amount of effort just to get 3 sentences because you start with these much bigger writings and nobody's happy, or at least enough people aren't unhappy that you wind up with 4 sentences.
Thank you for your time. So I was a little curious about the kind of human aspect of being a judge. Particularly, I was curious to what extent, if any, do decisions weigh on you? Do you find yourself unable to sleep? Maybe sometimes when you lose and you're in dissent, but even maybe sometimes when you win, because Professor Bonventre has made a big point about the rights of the accused. And, there are times when you need to vacate a conviction. And does it weigh on you at all? Maybe if the victim's family, they don't sleep the same at night because of the decision you make. Is it easy at all to separate your role as a judge from the human experience?
So I never think of myself as winning or losing these cases. I'm not the litigant, I'm the judge. And they don't keep me awake. I don't lose sleep over it. I'm a bad sleeper to begin with, but even when I'm on vacation and doing nothing, I'm a bad sleeper. This is my job. I do the best I can. And it doesn't weigh on me that way. The human element, I think the way it does figure into what I do is in what I write. Because I really try to write, whether it's majority or dissent, and it's actually easier in a dissent because I have fewer cooks, and also because it's not the law, is to humanize the story. That's the way I think that the human element, for me at least, comes into what I do. But once I'm done telling that story, it's gone, and I'm on to the next story. And if you ask me about a case I wrote, even 6 months ago by name, I won't remember it. If you start telling me the facts, maybe start to remember a little about it. There's a few like Tiger that I've been over and over and over, or Happy the Elephant, or maybe the gambling case, or the few like that I'll remember. But otherwise, I've moved on.
I think the issue is do you walk out of the courthouse on Eagle Street and do you take it with you And I think, the judge is right that generally that's not the case, but I do find, especially in times where you do get frustrated, a pattern of frustration, and then you have a particular case that just hits you where it hurts, And I think sometimes I found that sometimes it can just sit with me for days. But in general, you have to be able to separate those worlds, because if you do that in every case, you really not have much of a life when you leave, Eagle Street.
When I was a practicing lawyer for many, many, many years, I had clients, and then you actually are winning or losing. But the way I insulated myself from that is I told myself that, I never got the clients into the problems that they're in. They got themselves into these problems. And, I was doing the best I could. And if they won or they lost, they made the bed that they're going to lie in. And as long as I was reasonably happy that I did, as good a job as I could do, it just didn't. And so that, now that I'm not actually winning or losing, I'm just trying to decide things. It's very easy for me to disassociate myself from, I'm not winning or losing anything. I'm doing my best, deciding cases, and I'm moving on to the next one.
What I found interesting about that question, I don't know if you feel the same way, on the other side of the equation, on the head of the court system, there are sometimes very, very, you feel like you have the weight of the world on your shoulders. And with those, more so really than the adjudicative side, I sometimes would just, whether it be judges' pay raises or legal services for the poor, or whatever the issue was that you were advocating, for the system, for the judiciary. I found that a lot of those issues would just weigh on me, like I couldn't have a weekend, I couldn't have a life, because I was so tied up with some of those issues. And maybe it's more so for me because I came from a background where I did a lot of that stuff, and those issues were all that mattered for a while. And I just found that some of those larger issues more tied into public policy of the state and what's best for our citizens, and certainly what's best for the judiciary, often would weigh on me. Well, it's not good company. And, those things influenced the quality of my life at times, when you're involved in for instance, and you luckily will not have to do this, when we had to lay off 500 people and put them on the street because of a dispute. We're talking about relationships with the governor and the legislature. In this particular case, a dispute with the governor as to our budget, lay off 500 people, that kind of thing would affect me as a human being. Just no dealing with it, that you could come to any peace with it. So I think there are different aspects of this role that we're talking about today. And they all, you're a human being and affect you in different ways.
Just to thank you both again for being here. I was hoping that you would both speak a little bit to other state high courts. Obviously in your role, you're trying to uphold the rights of the citizens of New York, which we all appreciate. So thank you for that as well. And maybe just by way of narrowing, I was wondering, in each of your respective tenures, to what extent you might look to other states and like the states as laboratories of public policy model, to what extent you might have relations with the chiefs of other state high courts. And then maybe as a final add question, if there are any state high courts that you view as maybe being a distant second. Thank you.
So that actually raises a question, because I thought that some part of this was going to be an opportunity for me to get advice from Chief Judge Lippman. And so your question actually, it dovetails into something that I wanted to ask, because there is this conference of chief judges that meets twice a year, once a big meeting and once a smaller meeting. And so I've been to one of them so far, the big meeting last summer. I skipped the small meeting this time, and I don't see how I can possibly contribute anything meaningful to this conference. And all these other chief justices from other states not all of them, most of them, are working really hard. They have reports, they have committees, they do all this sort of stuff. And they all venerate this guy because apparently he was the superstar of this conference for many years. I don't have the time to do that, and I want to know, well, should I just forget about it? Should I cut something else out and pay attention to these people? You know,
I think it's a great question.
yeah. Good answer.
I hope you get a great answer. I think what happened is over a number of years, you got to we talk about dealing with other chief justices, some of whom you admire greatly. And you also got to deal with some states that are very similar to ours in size or complexity, like California, some of the northeastern states that, you know, may be smaller, like a Massachusetts, but has a particularly dynamic chief and similar problems. And I found that on more on the administrative side, but also sometimes in the adjudicative, you know, they have those organizations serve a lot of purposes. That you learn a lot by seeing systems that have similar problems. That you can learn from other states. And I'll give you an anecdote that came up during the years when I was fighting with one of our governors, and they had written a number of things about the judiciary that we were not happy about, and we did on the date of our State of the Judiciary. The press was there, and one of the tabloids was asking, why do you go to those meetings? You know, why do you spend the state's money to go and meet with these other chief justices or whatever? And they said, what makes it worthwhile? And it made me think, I mean, on the spot, it made me think. And I could honestly say to him, the particular reporter, that every one of the things that I've done and the different initiatives that we have in New York to make the judiciary better, in whole or in part, came to some significant degree from what I learned at those meetings. It may just be that they had a panel on something, and I sat there and said, oh, why can't we do that? Or, gee, isn't that an interesting idea? Or it may be a more full-blown initiative that someone else did, or it may be a similar problem that someone else had. But in my years, we would very much look to and talk to states that we felt, not that we didn't talk to the little states or the prairie states or the, you know, more rural states, but there was a camaraderie and a sense of common purpose with a number of those chiefs and a number of those states. And I did feel the answer that I gave at that time was true, that so much of what we do fed off what I learned from these others. And I do think that, and Vin knows, because we've had, and he's had, apart from when I've been here, but at times when I have, where I've moderated, or Vin, the professor has moderated discussions with other chiefs from other states, some of whom you would not think would be people that would make you expand your, you know, your intellectual thoughts about running a court system, or on the adjudicative side, whether it be Christine Durham in Arizona, or so many others like that, who really were inspirational in many regards. So I do find it a value in it, but I can understand how you could go to these things and see all these different, some of whom have nothing in common with you other than being nice people, you know, and it really does take a while to get your mindset and what am I doing here and why? And how does it serve the New York State judiciary?
My concern is more, I'm pretty content to be a freeloader at this. I feel as if I have the time to contribute my share meaningfully of helping them, and that makes me feel a little
That's the
bad.
100% argument. You spend your 100% here and there, and you're gonna spend 100% there.
Yep.
And I suspect you will, knowing my customer, I suspect you will.
There is actually on this topic, something that I intend to try and find out about other state courts, which is, I'll short circuit this a lot because I don't want to go into details, but it has taken, you would not believe the amount of effort, not just of mine, but of all kinds of other people within the court system to get the Trump trial transcripts on our website. You would think that would be a simple thing to do. It has been, and it's ongoing, and it's not, still not, there's still discussions going on about it.
Did I read that you were doing it?
It's done. It's there, but even it took a tremendous amount of effort to get it there, and there still are gnashing of teeth and, recriminations and all sorts of things that going on. What I'd like to do is to talk to some state courts that do this regularly and figure out in what ways our system is different and what works for them and why, because it shouldn't have been, to me, this is a no-brainer, right? This is,
Public service.
is this as important as Watergate? Maybe not, but it's of the same ilk.
But what's interesting? You talk about the issues that link us as judiciaries. One of the related issues, and I'm not saying to do or not to do, is cameras in the courts. During the heyday where that issue was such a vibrant one, and you remember OJ and Ito and all that stuff, we were comparing notes and all of that. I, for one, and I don't think any magic answer here either, believe in cameras in the courts with all the controversy about whether the OJ trial served the public interest. I think if cameras in the courts were a commonplace thing and it became a learning tool that people learned what the courts were about, I think it'd be a good thing. But it's a perfect example of where you can look at what other people are doing, whether it's that issue or this simple issue that you just can say, why can't we do this?
Yeah, and certainly when you look at cameras in the courts and look at the other states and you find out that the only other state that prohibits cameras in the courtroom is Louisiana, it makes you wonder.
Well, OJ trial cured everyone of that.
Well, when we're talking about other state courts, I want to say, we had a Cooke Symposium quite a few years ago, great women, great chiefs. Judith Kay couldn't be here for some reason, and Lippman was not here.
I don't
Lippman
understand.
was not here. We didn't invite Lippman.
Listen, I'm a feminist.
Yeah, I
Right?
know.
All right.
Anyway, so several of the law review students and myself, we went out to dinner with Margaret Marshall,
Who is one of
Massachusetts,
my favorite people in the world. and
Christine
great
Durham
judge.
of Utah, can't beat her, Shirley Abramson of Wisconsin,
The
who's a
greatest.
New Yorker.
Great, transplanted to New York.
And while we're at dinner, they volunteered to me, we're all following the Court of Appeals with Jonathan in charge. Yeah. With regard to you, Wilson, the governor has talked about, appointing you to make sure the Court of Appeals is the preeminent court. A lot of commentators and the legislators are saying the same. So your feet are on the fire, right?
I was on the court before that, though. I think that the person that probably best applies to is Halligan. And she also appointed Judge Troutman. So she's made some pretty good picks in my view.
Yeah.
Right, so, I think maybe one last question, if I can ask one question, because you kind of prompted it, actually.
Okay, she's gonna let you ask the last question.
I doubt it.
Some notice.
It's not going to play out that way.
Sure, there wasn't too much uproar around that. So as Chief Judge Wilson's predecessor, do you have any advice for Chief Judge Wilson? And Judge Wilson, is there any advice you'd like to receive from Chief Judge Wilson?
He doesn't need my advice.
No, of course not.
But what I would say to him, which I think he's proven already that he knows how to do, is that one, we have a strong chief judge system for a reason. And one of the things that I learned from going to all these conferences, you can't imagine the difference between states that are decentralized in terms of how they run the court system and the good you can do in a state that has since the 1970s, Ritel and the constitutional amendment, the strong chief judge system led by the chief judge and by delegation to the chief administrative judge, you have a pulpit that nobody else has, certainly in our judicial system, but also in many judicial systems around the country. And I guess my only advice, which I know you're doing already, so you don't need my advice, is that this pulpit allows you to go beyond, and I don't mean this as being critical. Even I was sued by the State Bar Association, by whoever, that the politicians and the profession are often more parochial, and that we're not or shouldn't be. And he can use that pulpit and that moral, high ground with the system that we have to do so much good. And I've already seen how much good you've done in such a short period of time. And I know that I have great confidence, many more wonderful good things to come.
So I can answer the second part of your question, which is Chief Judge Lippman has an inordinate number of amazing qualities. But one of them that is very rare is the following, and I can illustrate it by this. He has, can you imagine the temptation of a great former chief judge to give advice to a novice? I mean, it's unbelievably tempting, right? And for good reason, for good cause, right? He has never once offered me any bit of unsolicited advice, but every single time that I've asked him for advice, he has given me careful, thoughtful, sage advice. That I couldn't do that. I couldn't restrain myself from that. But he has just been marvelous. And he's never said to me, this is what I'm doing. I'm not intruding, but I will always be a resource for you. But he's made that so obvious to me by that pattern. It's just, he is a great resource for me, but he's also letting me make my own mistakes if I'm foolish enough to do that.
Not very many of those.
Well, that's because I keep asking for good advice.
This has been an extraordinary event, and I'm sure my dear friend, Chief Judge Lawrence Cooke would be very, very honored to have these two great chief judges here. And so really, let's thank them. I mean, this is amazing. I also want to applaud the students of Albany Law School for being smart enough to come to Albany Law School, because nobody else gets this. And our new dean, she's a new dean. Did she realize how great this law school was? She did. But anyway, thank you so much to the Law Review, to Kyle and Marie-Therese and everybody else on the Law Review that has helped so much. And Kanika, I mean, really, who could put up with me? But thank you all so much. And thank you, Chiefs. You're the greatest. Thank you so much.